Tomorrow, everything could change. June 13 is not just another court date. It could be the day the government finally breaks the courtroom. The courtroom is tense, the judge is watching, and the world is waiting. After years of drama and delay, Nnamdi Kanu is back in court. But this time, something is different. The government's main evidence struck out.
Court hearing
with Judicial Matters, Justice James Omotosho, in a trial within trial of the federal government's case against Nnamdi Kanu, dismissed the allegations of coercion made by the leader of the indigenous people of Biafra, Nnamdi Kanu, against the Department of State Services. Justice Omotosho held that Mr. Kanu did not establish involuntariness in any way during his interview by the DSS. Senior reporter Celestina Iria reports.
The judge held that the video played in court showed that the statements were taken in a cordial environment and no sign of coercion was noticed. However, the court said it cannot close its eyes to the fact that Mr. Kanu was regularly complaining about the absence of his counsel. Section 15 of the ACJA provides that where a suspect is arrested without a warrant, his statement must be obtained in the presence of his counsel, and where a counsel is not available, it will be in the presence of an officer of the Legal Aid Council of Nigeria or a member of the civil society. Even though the statements were recorded in video, the fact that the lawyer of the defendant is not available makes the statement inadmissible in evidence. The court said it is empowered to also expunge the video recordings which had been admitted in evidence. Having established the statement is inadmissible, the court ordered as follows. 1. The statement of the defendants dated 21st to 24th October and November 4th, 2015 are inadmissible in evidence. 2. The video recording of the statements, also declared inadmissible, are hereby marked rejected. After the ruling, Justice Omotosho singled out Favour Kanu, Nnamdi Kanu's sister-in-law. He proceeded to ban her from ever coming to the trial and also bar her from accessing the court premises unless she has a matter in court. Justice Omotosho said henceforth he will be sending people to Kuje prison for contempt in the face of the court. Shortly after the prosecution court is thought witness to continue his examination in chief, Mr. CCC told the court about a video recording of one Sahara reporter's interview with Nnamdi Kanu, which DSS played for Kanu during the interview of October 21st, 2015. A CD plate containing the interview was tendered and admitted in evidence, after which it was played in court. The interview started with the interviewer asking Kanu about his opinion on the national conference when retired General Ike Onwachukwu was appointed to lead Igbo delegation. Kanu castigated Ike Onwachukwu, saying he was part of the Nigerian army that killed Igbo in Asaba during the war. Summary of the interview as transcribed. If they underestimate us, what happened in Somali will be a child's play to what will happen here. All governors of the southeast are put in by Hausa Fulani men and they do their bidding. I choose both sides to get Biafra. If they give us Biafra in peace, wonderful. If they want war, I can assure you that there will be nothing living in the zoo they call a country. I have never seen where any people get freedom through peaceful means. I welcome what the Biafran Zionist movement did by attacking Enugu State Government House. Anybody that can do anything to disrupt the way things currently are in this zoological republic is welcome. During cross-examination by Mr. CCT, he maintained that the defendant clearly said he would actualize his goal either through war or through peace. He admitted that Ike Onwachukwu was not killed after the conference by Kanu or his supporters, as well as Peter Obi and Rochas Okorocha, who the defendants mentioned in the video. Justice Omotosho adjourned the matter till June 13, 2025 for continuation of hearing.
That's right. No proof, no case, no excuse. And now the question is clear. We can't walk free. Stay with us because this is the full breakdown. Let's rewind a bit to understand why June 13 is matter. We must remember how this all started. Mazi Nnamdi Kanu, IPOB leader, freedom fighter, a man who gave voice to the voiceless. He was taken in 2021 illegally, secretly from Kenya to Nigeria. No extradition, no fair process, just a plain violation of international law. Since then, he's been held by the DSS, locked up, dragged in and out of court without justice. And every time he shows up in court, the same pattern plays out. No real evidence, no strong evidence, just delay after delay after delay. Now, fast forward to May 21, 2024. Supporters gather, the courtroom was full, Kanu was there, his lawyer were ready, and Nigeria were watching. But once again, the prosecution had nothing, no surprise witness, no new argument, just weak evidence and old tactics. The defense too strong, they challenged every move, and right there in court, the judge began to see the truth. Let's talk about what really happened on May 21, because that day changed everything. The Federal High Court, Abuja, security was tight, tension in the air. Mazi Nnamdi Kanu was brought in again, still handcuffed, still silent. This time, his legal team came prepared. The government arrived empty-handed again. The prosecution stood up first. They were supposed to present evidence, but instead, no new document, no video proof, no single witness inside. Just the same recycled argument, same DSS statement, same old charge of terrorism and incitement. But here is the twist. The judge was not impressed. The defense fired back. Then came Kanu's legal team, led by Aloy Ejimako, Barrister Aloy, and Mike San. What they said in court shocked the room. The bombshell argument, they told the judge clearly, "Your Lordship, this man was abducted, not extradited, and that alone makes this entire trial illegal." They brought up the ruling from the Supreme Court from back in December 2023. It clearly stated Kanu was illegally redemption from Kenya. So technically, it should not even be standing trial in Nigeria. The Supreme Court warning, let's be clear, the Supreme Court didn't say Kanu was guilty. He didn't say he was innocent either. But he did say due process was violated, and that is serious. Because in any real democracy, illegal arrest case thrown out. At the moment, you could feel the courtroom shift. The judge leaned forward. The prosecution grew quiet. Even DSS agent began whispering, and then the refire started. Government key evidence gets destroyed. The defense point to the prosecution so-called evidence. Some blurry video clips, old online broadcast statement taken under pressure. They said none of this meets the standards for criminal trial. And then the judge agreed. One by one, the items were declared inadmissible. That was shocked the room because it meant the government case was falling apart. Why this so important? This wasn't just a win for Kanu. It was a turning point because if the prosecution can use its best material, what left? Rumors, politics, fear. None of that we hold in court. And the judge knew it. What the judge said. Reports said the judge warned both sides. No more delays. He said the court will not be held hostage by endless argument. He gave the prosecution one final chance, June 13. The judge wants closure and the world is watching. By now, even the prosecution is starting to panic. They have played every card, they have tried every delay. But in the courtroom, facts still matter. And their facts don't exist. Let's review the charges. What are they accusing Kanu of? Terrorism, inciting violence, running a proscribed group, calling for section. Here is the truth. None of these charges have been proven. Not in 2021, not in 2022, not even now in 2025. They say IPOB is a terrorist group. But has any international court agreed? No. Has any human rights court supported the prosecution? No. IPOB doesn't plant bombs. They don't hold civilians hostage. They ask for referendum. What about incitement? The government claimed Kanu made inciting broadcasts. But ask yourself, where were the original tapes? Where were the witnesses who act based on his word? No names, no testimonies, no evidence. Even DSS is out of tactics. The DSS used to come to court, bold, confident, but now they are silent. No fresh exhibits, no new arrests, just empty uniforms. Court noticed the pattern and the judge is not blind. He's seen this before, delay after delay, week file after week file. no direct evidence. And now that the key items were ruled out, the court is left with hollow case, a silent admission of defeat. You want to know how weak this case is? They didn't even ask to present witnesses on May 21. They just hope for another adjournment. That is not how a confident prosecution behaves. That is not how justice works. Behind closed door, panic, some say government insiders are worried. They know if this case collapses publicly, it will be a massive political embarrassment. The international community is watching. Right groups are watching. Millions of Nigeria are watching. Kanu's lawyers are calm, focused. Meanwhile, Kanu's legal team, they are more confident than ever. They know the facts. They know the court rules. They know the government is out of time. All eyes on June 13. So what happens next? That is what June 30 is about. This trial may not just continue, it may end. The prosecution has no more room to hide. And if they fail again tomorrow, the judge has every right to throw out the case.